The first time my father laughed at me in court, the entire room joined him. Not loudly, not cruelly, just enough. The kind of quiet courtroom laughter people use when they think they already know how the story ends. I walked into that courtroom completely alone. No attorney beside me. No family support. No expensive suit. Just a single folder in my hand and years of silence sitting on my shoulders. And across the room? My father looked relaxed. My mother looked satisfied. My brother looked bored. They thought this would be over in minutes. Because what they didn't know, what none of them knew, was that the woman they had spent years underestimating had been trained by the United States military to dismantle arguments for a living. And before that hearing ended, the same people who mocked me would be staring at me in complete silence while the judge called me by my rank, Major Carter. But to understand how we got there, you need to hear what happened inside that courtroom. The moment I stepped through those courtroom doors, I felt it. The shift. Conversations softened just enough to make room for judgment. A few heads turned and stayed a second too long. Not curious. Not sympathetic. Certain. Certain they already knew exactly who I was. Or more accurately, what I wasn't. My father didn't even try to hide his amusement. Couldn't afford a lawyer? He said loudly enough for the people behind him to hear. That's unfortunate. A few people chuckled. Soft. Polite. Controlled. The kind of laughter designed not to attract attention while still hitting exactly where it's supposed to. I didn't answer him. Because I already knew something they didn't. And in less than an hour, every person in that courtroom would know it too. The courtroom smelled faintly like old paper and polished wood. The kind of room where decisions seemed to stay trapped in the walls long after people left. I stood beside the defense table, hands loosely folded, posture steady. Across the aisle, my family looked completely at home. My father sat at the center in a perfectly tailored navy suit, relaxed in the way powerful people get when they assume the outcome belongs to them before anything even begins. My mother sat beside him, pearls resting neatly against her collarbone, lips pressed into that familiar thin line I knew far too well. To most people it looked composed. To me, it meant she was pleased. My brother leaned back in his chair with one ankle resting over his knee, barely acknowledging me at all. Their attorney stood nearby flipping through a thick binder full of tabs, exhibits and prepared arguments. Organized. Comfortable. Confident. Everything I was never supposed to be. I could still hear my father's words echoing in my head. Can't afford a lawyer. He never asked if I had one. He assumed. And the room agreed with him. I shifted my weight slightly, letting my eyes move across the courtroom calmly. The judge's bench was still empty, but the clerk was already arranging documents with mechanical precision. Behind me, a couple whispered quietly to each other. Near the back, someone clicked a pen over and over. Ordinary sounds. But beneath all of it sat tension. Thin. Sharp. Invisible. Still time to reconsider. My father said quietly now. You don't have to embarrass yourself like this. I turned just enough to meet his eyes. There it was again. That certainty. That quiet confidence people carry when they think they've already won. I'm not embarrassed, I said calmly. My mother let out a small dismissive breath. Of course you aren't, she murmured. My brother smirked. Their attorney leaned toward my father and lowered his voice. We'll keep this simple, he said. Given her situation, I don't expect almost enough to make me smile. Almost. I looked down at the folder in my hands. It wasn't thick like theirs. No color de tabs. No stacks of paperwork. Just a clean folder with every page exactly where it needed to be. They thought that meant I was unprepared. They were wrong. The bailiff stepped forward. All rise. Chairs scraped back instantly. Conversations vanished. The judge entered with measured steps, expression unreadable as he scanned the room. We sat after he did. Case number 47 to 218, the clerk announced. Petition regarding estate distribution and contested ownership. Estate ownership. Such clean words for something that was never clean. The judge adjusted his glasses and looked toward my family's attorney. Counsel. The attorney stood immediately. Your Honor, this is a straightforward matter. My clients seek resolution regarding property that was clearly never intended to remain in the defendant's possession. He gestured toward me without looking directly at me. The defendant is appearing without legal representation, which may limit efficiency, but will keep the matter concise. A few faint nods came from the gallery. Of course. Proceed, the judge said. Their attorney began laying out the case smoothly. Dates, signatures, property transfers, ownership assumptions. His voice carried the polished confidence of someone used to controlling rooms like this. And on paper? It sounded convincing. If you didn't know what to listen for. I stayed completely still while he spoke. Didn't interrupt. Didn't react. I followed every sentence carefully. Every omission. Every assumption. Every weak point. Because assumptions are where cases fall apart. At one point he paused and glanced briefly in my direction. Given the absence of any meaningful counterargument from the defendant, he continued, we believe the court will rule in favor. Silence mistaken for weakness. The judge looked toward me. You'll have an opportunity to respond. Yes, Your Honor. My father leaned back slowly, looking almost bored now. My mother adjusted her bracelet with precise movements. My brother didn't bother looking at me anymore. They were already treating this like it was finished. I closed my folder gently. The soft sound barely carried. But my father noticed. For the first time that morning his expression changed. Just slightly. Not confidence. Not dismissal. Curiosity. That was enough. The attorney finished his opening statement. No further remarks at this time, Your Honor. The judge turned to me. Whenever you're ready. I took a small breath. Nothing dramatic. Then I stepped forward. Thank you, Your Honor. And for the first time that morning, the courtroom became completely still. I didn't begin with an argument. I didn't raise my voice. Instead, I let silence settle for a moment. Not long enough to look uncertain. Just long enough to change the rhythm of the room. Silence, when used correctly, forces people to listen. My name is Emily Carter, I said clearly, and I'll be representing myself today. No reaction from my family. They had already dismissed that fact. The judge nodded. Go ahead, Miss Carter. I glanced down briefly at my folder. Before addressing the claims presented today, I'd like to clarify several points regarding the nature of this dispute. Their attorney shifted immediately, preparing to interrupt. I could see it in his posture. He expected confusion, hesitation. He got neither. This is not simply a disagreement over property, I continued. It's a question of intent, control, and the timeline of ownership decisions made prior to my departure from my family's residence. I was 19 when I left home. There wasn't a dramatic fight. No screaming. Just a conversation that ended in a silence I didn't understand back then. The kind of silence that doesn't ask you to stay. You're making a mistake, my father had said without looking up from his newspaper. I'm making a choice, I answered. He turned the page. That was it. My mother didn't stop me. Didn't argue. She simply watched me pack like she was observing something inevitable. My brother laughed. Military, he said from the doorway. That's where people go when they run out of options. At the time, I wasn't entirely sure he was wrong. Back in the courtroom, I grounded myself in the present. The plaintiff's argument, I said, rests on the assumption that I forfeited my interest in the property when I left. Their attorney nodded immediately. That is correct, Your Honor. The defendant left voluntarily and made no claim for several years afterward. I let him finish, then tilted my head slightly. Voluntarily, I repeated. That's an interesting choice of wording. A flicker of irritation crossed his face. The judge leaned forward slightly. Clarify. At the time I left, I said calmly, I was given two choices. Remain under conditions that restricted my independence, or leave without financial support, without access to shared assets, and without any expectation of return. My mother shifted slightly, subtle, but noticeable. That is not legal coercion, the attorney interrupted quickly. It was a family disagreement. Perhaps, I replied evenly, but it's relevant to intent. He opened his mouth again, then stopped, because he didn't yet have a clean way around that. And slowly, the room began to change. Not visibly. No one gasped. no dramatic reactions. But certainty started. 7 years was not a small detail. During that period, I added, I was never asked to sign away ownership. I was never informed of any transfer. I was never contacted regarding legal restructuring. That's because, my father snapped suddenly, you made it clear you wanted nothing to do with us. His voice carried farther than he intended. The judge looked at him sharply. Sir, you'll wait your turn. My father leaned back again, jaw tight. I never looked at him. I didn't need to. 7 years. They used that timeline like it erased responsibility, like silence automatically meant consent. But time doesn't erase intent. It reveals it. I returned only after learning of a pending sale involving the property, I said. Their attorney straightened immediately, which occurred long after any reasonable expectation of claim. After I had been excluded from all communication involving the property, I corrected calmly. He stopped talking. Not because I overpowered him. Because I didn't need to. The judge made another note. That was the second shift. Small. Quiet. Real. I could feel my brother watching me now. Really watching. He didn't recognize this version of me. That was fine. He wasn't supposed to. I removed a single document from my folder, but didn't hand it over yet. Timing mattered. Everything here depended on timing. I understand the assumption being made, I said. That because I left, I abandoned my claim. That because I remained silent, I accepted every decision made afterward. I let the words settle. But assumptions, I added softly, are not evidence. The sentence landed cleanly. No theatrics required. Their attorney inhaled slowly, recalculating. I could see it happening in real time now. He was adjusting strategy, trying to narrow the argument, trying to regain control. Your Honor, he said, stepping forward again, even under the defendant's interpretation, inactivity over such an extended period strongly implies abandonment. Without formal relinquishment, I finished calmly. He stopped mid-sentence. The judge looked up fully this time. Really looked at me. Not at the papers. At me. And for the first time, I saw interest. Not recognition yet, but focus. I lowered my gaze slightly, pretending not to notice. Because this was where everything started changing. Not dramatically. In fractures. Hairline cracks spreading through certainty. My intention isn't to complicate proceedings, I said quietly. Only to ensure accuracy. The judge leaned back slightly. Proceed. And for the first time that morning, it no longer felt like I was defending myself. The shift continued quietly. Their attorney felt it too. I saw it in the way he adjusted his stance. No longer comfortable. No longer relaxed. Now he was thinking carefully, which meant he was no longer certain. Your Honor, he began again. Even if the defendant argues technical retention of ownership, the practical reality remains the same. She has had no involvement with the property for years. No maintenance. No financial contribution. No communication. He let each point hang. Functionally, he concluded, her claim is disconnected. Disconnected. Another carefully chosen word. I nodded slowly. I agree. That caught him off guard immediately. You agree? Yes, I said calmly. I have been disconnected from the property, from the decisions surrounding it, from the communication involving it. I stepped slightly closer toward the center of the room. Not aggressive, just present. Proceed, the judge said. 7 years, I began. That's the number repeatedly referenced today. 7 years of silence. 7 years of absence. I looked briefly toward my father. No smirk now. Only calculation. I'd like to focus specifically on year 3. The attorney's expression changed instantly. Year 3 wasn't part of his preparation. I was stationed overseas at the time, I said. My communication access was limited, but not non-existent. I received official notices regularly. What I did not receive was any communication regarding changes to the property. That's because no formal change had occurred, the attorney interrupted quickly. I nodded. Correct. Again, agreement where he expected resistance. But, I continued. That was the year preliminary restructuring discussions began. The room went still. Objection, the attorney said immediately. Speculation. I have documentation. The objection died instantly. The judge looked toward me. You'll present it shortly? Yes, Your Honor. Now the courtroom wasn't just listening. It was waiting. My point, I said, is not that legal action was finalized at that stage. My point is that discussions affecting ownership had already begun without my knowledge. The attorney stepped forward again. Preliminary conversations are not legal violations. Agreed. I answered immediately. Again he stopped. Because I wasn't fighting his surface argument. I was removing the ground beneath it. But hypothetical discussions often become concrete decisions, I said. I placed a second document beside the first. And when those decisions move forward without required notification, that becomes relevant. The judge looked toward the documents. Across the room, like he was trying to reconcile the person standing in front of him with the daughter he thought he knew. You've structured this argument around absence, I told the attorney. Around the assumption that lack of involvement equals lack of claim. That's a reasonable interpretation, he replied. It's a convenient interpretation, I corrected gently. The distinction landed immediately. Because it assumes involvement was ever truly offered as an option. Silence. Heavier this time. Not uncertain. Focused. Your Honor, the attorney said tightly, we are drifting away from the core issue. The ownership structure is directly tied to the decisions preceding it, I replied calmly. He exhaled slowly. This recalibration took longer. The judge leaned forward. Ms. Carter, he said, are you suggesting your family initiated actions affecting ownership without proper notification? Yes, Your Honor. And you intend to demonstrate that? Ido. A brief pause. Then proceed carefully. Not a warning. Recognition. Carefully. I almost smiled. I touched the first document lightly. Not yet. Not until it mattered most. Before I submit these, I said, there's one more point worth clarifying. The attorney stiffened again. He hated surprises now. My family has presented this as a simple dispute. I continued. A straightforward matter with an obvious outcome. I let my eyes move briefly across the courtroom. But simple cases, I added quietly, usually don't require this much effort to control the narrative. The sentence settled over the room. No one moved. Then the judge spoke. Ms. Carter, you appear unusually familiar with procedural strategy for someone without legal representation. There it was. Close to the real question. Very close. I met his gaze. I've had some training, I answered. He began wondering who exactly he had underestimated. The word training stayed in the room long after I said it. Their attorney adjusted his cufflinks. Not because they needed adjusting. Because his hands suddenly did. My father shifted in his seat. My brother leaned forward further. The question had already formed in everyone's mind. What kind of training? I didn't answer immediately. Timing still mattered. Your Honor, the attorney interrupted, trying to regain momentum. Regardless of the defendant's familiarity with legal terminology, the facts remain unchanged. My clients maintained the property for years. Managed it. Invested in it. He turned toward the judge. And the defendant's sudden reappearance coincides rather conveniently with a pending sale. Convenient. Another word carefully chosen to shape perception. I ignored it. Timing matters, I said calmly. But sequence matters too. I slid the first document fully forward. This is internal correspondence between my family and a third-party broker, dated approximately 18 months before the sale process officially began. The clerk retrieved it. Their attorney's jaw tightened immediately. He hadn't expected evidence like this. Your Honor, he said carefully, informal correspondence should not be overvalued. Preliminary discussions are not legal action. Of course not, I agreed. Then I continued. But they do establish intent. The judge read silently. Then more slowly, that phrase appears repeatedly throughout the correspondence. I continued, always referring to individuals who were absent and therefore not consulted. Out of context, the attorney interrupted quickly. Then explain the context, the judge said without looking up. The attorney hesitated. Just 1 second. But 1 second is enough in a courtroom. The wording reflects logistical concerns, he said finally. Not intentional exclusion. Standard phrasing? I asked softly. Then I placed the second document beside the first. This is a follow-up exchange 6 months later. The judge read. This pause lasted longer. Because the language was less careful now. More direct. In this exchange, I said, the discussion references finalizing decisions before any future claims can be raised. Silence. No interruptions now. Because there was nothing left to deny. The documents were speaking for themselves. My brother rubbed a hand through his hair slowly. My mother's posture remained perfectly rigid. And my father was staring at the table. Ms. Carter, the judge said carefully, you're suggesting these communications indicate deliberate efforts to proceed without notifying all parties who maintained ownership rights. Yes, Your Honor. And you were one of those parties? Yes. The attorney stepped forward again. Even if that interpretation is accepted, the defendant still remained silent throughout this period. He turned toward me. Silence has consequences. I met his eyes. It does, I agreed quietly. But only when silence is a choice. The sentence settled heavily into the room. Explain, the judge said. Silence assumes awareness, I answered. It assumes someone knew what was happening and chose not to respond. I paused. Lack of notification removes the opportunity to respond entirely. Another beat. And without opportunity, there can be no meaningful because the argument had shifted completely now. This was no longer about whether I spoke. It was about whether I had ever been given the chance to, and that was far harder to defend. The judge studied me carefully. You've built this argument very precisely. Yes, Your Honor. Then he looked toward opposing counsel. Counsel, were you aware of these communications before today? The question landed like a dropped stone. The attorney hesitated. I was not provided with these specific documents. Another ripple. The judge's expression changed slightly. Should you have been? Real silence filled the room then. My father finally looked uncertain. And once certainty cracks, it never fully returns. The judge repeated himself. Should you have been? The attorney glanced toward my father now. Not for confidence. For support. My father gave him nothing. Your Honor, the attorney said carefully. I can only work with materials provided to me. If additional communications directly related to ownership existed, the judge replied quietly, then yes, you probably should have received them. The sentence wasn't loud, but it changed the room. The careful narrative my family built was unraveling now. Quietly, publicly, completely. The judge turned back toward me. Ms. Carter, you've demonstrated significant familiarity with procedure, evidence handling, and legal framing. A pause. You also mentioned having training. Direct now. No circling. Yes, Your Honor. What kind of training? Every eye in the courtroom shifted toward me. My brother looked tense now. My mother had gone completely still. And my father. For the first time then the judge's expression shifted. Military. Yes, Your Honor. He nodded slowly. That explains the structure. Their attorney exhaled sharply through his nose. Now he understood. He hadn't been arguing against an overwhelmed daughter appearing alone in court. He had been arguing against someone professionally trained to dismantle weak legal assumptions. Your Honor, he tried again. The defendant's background does not alter the legal standing of the case. It alters how I evaluate her arguments, the judge replied calmly. A line had been drawn. Clear. Final. The judge looked back toward me. Are you currently serving? Yes, Your Honor. Rank. Major. This time the room reacted. Quietly, but unmistakably. Someone shifted in their chair behind me. My brother's eyes widened briefly. My mother gripped her bracelet tighter. And my father looked like the ground had shifted beneath him. Jagcor. The judge asked. Yes, Your Honor. That confirmation changed everything. The courtroom understood now. Not fully, but enough. The judge turned toward opposing counsel. Counsel, did you know the individual you repeatedly described as unrepresented is a commissioned officer trained in military legal practice? The attorney opened his mouth, closed it, then answered quietly, "No, Your Honor." The judge tilted his head slightly, then asked the question that changed the room forever. Did you truly not know who she was? The impact was immediate. The attorney froze completely. My father went pale. Not slowly. Instantly. My mother's composure cracked in the smallest visible way. My brother looked between all of us like reality itself had shifted. And I stood exactly where I had been standing and suddenly the entire courtroom saw me differently. Not louder. Not harsher. Clearer. The title changed everything. What they once interpreted as passivity now looked like discipline. What they mistook for weakness now looked like control. I simply nodded. "Thank you, Your Honor." I requested both exhibits be entered into record. "Admitted," the judge said. The papers were stamped. Formal. Permanent. Their attorney inhaled slowly. He was still trying to salvage ground. "Even if these communications are accepted," he argued, "they do not prove Major Carter was entitled to notification at that stage. Operational control remained with my clients." There it was. The pivot. He could no longer deny intent. So now he focused on authority. Operational control. I repeated softly. I stepped slightly toward the center again. That term implies a structured authority system. Define boundaries. Define permissions. The judge nodded. "Yes." "Then I'd like to clarify those boundaries." I removed another document from my folder. Smaller. Simpler. Far more dangerous. "This is the original ownership agreement executed before my departure." The clerk handed it to the judge. This time he read slowly. Very slowly. Across the room my father sat up straighter. My mother clasped her hands tightly together. My brother leaned back again like he wanted distance from all of it. "The agreement establishes shared ownership among all listed parties," I explained. "No clause grants unilateral authority over structural decisions without unanimous acknowledgement." The attorney stepped forward weakly. "Agreements like this are often interpreted flexibly in practice." "Flexibility," I interrupted calmly, "does not erase requirement." He stopped. Because there was nowhere left to pivot. "The agreement is explicit. I am listed." Silence. Heavy now. Definitive. The judge closed the document slowly. "Counsel," he said toward the opposing attorney, "were these provisions considered when preparing your argument?" Another hesitation. "We interpreted the management clause as permitting interim authority." "Interim authority," the judge repeated evenly. "Not structural authority." A pause. "Would you agree?" The attorney swallowed once. "Yes, Your Honor." And just like that, the foundation collapsed. My father suddenly leaned forward. "This is being distorted." "Sir," the judge interrupted calmly, "you will not interrupt proceedings again." My father sat back slowly. But the confidence was gone now. Completely gone. "The sequence presented," I continued, "demonstrates a consistent pattern. Initiate discussion. Proceed without notification. Finalize decisions before acknowledgement can be requested." I paused. That is not oversight. Another beat. It is exclusion. The word landed firmly. No one argued with it. The attorney made one final attempt. "Your Honor, regardless of procedural concerns, my clients invested heavily into maintaining this property, financially and otherwise. That contribution deserves consideration." It was his last remaining angle. And honestly, part of it was valid. "I don't dispute their contributions," I answered. Again, agreement. But he knew better now than to relax when I agreed. "The property has increased in value," I continued. "That reflects effort." Then I added quietly, "But effort does not override agreement." The distinction held perfectly. Sharp. Clean. Final. The judge looked down at the exhibits one final time. Then back up. The court fined. Furthermore, the communications entered into record indicate awareness of those requirements and deliberate efforts to proceed without fulfilling them. My mother's hands tightened. My brother looked away. My father didn't move at all. As such, the judge concluded, the restructuring actions regarding the property are procedurally invalid. One last pause. Measured. Final. The court rules in favor of the defendant. No dramatic gavel strike. No shouting. Just words. And the weight they carried. The room stayed quiet afterward. Not shocked. Just settled. People began gathering papers. Chairs moved softly against the floor. The ordinary sounds of endings. I stayed where I was a moment longer. Not because I had to. Because I chose to. Major Carter. The judge's voice reached me quietly. I turned. Yes, Your Honor. He held my gaze briefly. Clear presentation. Simple. Professional. But meaningful. Thank you, Your Honor. He nodded once and moved on to the next case. Because that's how courtrooms work. Life-changing moments for one person become routine for everyone else. I gathered my documents carefully. Every paper returned exactly where it belonged. No shaking hands. No ruse. Just control. Emily. The voice stopped me before I reached the door. I hadn't heard my name spoken like that in years. I turned slowly. My father was standing now. So was my mother. My brother remained seated. Eyes fixed downward. You didn't have to do this here, my father said quietly. No arrogance left now. No makiri. I faced him fully. I didn't choose the setting, I replied. You did. He exhaled slowly. That's not what I meant. No, I said softly. It usually isn't. My mother stepped slightly closer. We didn't know. You could have told us. There was no anger in his voice. Only confusion. I could have, I answered. But it wouldn't have changed anything. Silence settled between us again. Honest silence this time. Because this was never really about missing information. It was about perspective. And perspective rarely changes just because new facts appear. My father stepped slightly closer. Not enough to close the distance. Just enough to acknowledge it. You made your point, he said quietly. I studied him for a moment. The man who once looked at me like I was a disappointment, he didn't care enough to stop. Now he looked at me like he was trying to understand something that had been there all along. I didn't come here to make a point, I said. His brow tightened slightly. I came because something that belonged to me was being taken without my knowledge. I let the truth sit between us. That's all. No anger. No bitterness. Just clarity. My mother spoke again, softer now. You could have come to us first. I almost smiled. Not because it was funny. Because it was familiar. I did, I said. She looked confused. When I left, I clarified. That was me choosing not to stay somewhere that refused to see me. No one answered. Because there was, I don't need anything else from you, I said. And I meant it. I turned and walked toward the light spilling through the hallway entrance. Steady. Measured. Unhurried. I didn't look back. Because there was nothing left to prove. Outside the courtroom, the air felt different. Not lighter. Just open. And for the first time in years, I wasn't carrying anything that didn't belong to me. If you've ever been underestimated, if someone has ever decided who you were before truly seeing you, then you understand this moment. Tell me honestly, what would you have done in my place? Would you have stayed silent? Or would you have waited until the truth could speak for itself? Leave a comment below and tell me where you're watching from. And if stories like this resonate with you, stories about quiet strength, discipline, and proving people wrong without ever raising your voice, subscribe to the channel and stay with us. Because sometimes, the strongest people in the room are the ones nobody notices until it's already too late.